Good evening and welcome. I'm delighted to welcome you all here to the law school for this year's James Madison Lecture, which is really one of the premier events on our annual calendar, our most prominent public lecture. The Madison Lecture got its start in 1960, and the inaugural lecture was presented by Justice Hugo Black. And in it, he illustrated his theory of the absolute protection of free speech. And ever since then, the lecture has been an occasion for us to hear from leading jurists in the country and to provide thoughts that have become formative in our thinking about American public law and rights under the Constitution, as well as the functioning of the judiciary. This is a wonderful tradition, not only for our law school, but if I may say so, for American law more broadly, and we are thrilled and honored to continue it. And tonight we welcome Judge Gerard Lynch of the U.S. Court of Appeals for the Second Circuit. We are very glad and honored that he is this year's Madison Lecturer. He will be formally introduced in a few minutes by our colleague, Professor Stephen Gillers, but let me just say personally, Judge Lynch, how grateful I am to you for being here this evening. I thought I would take a moment just to note something familiar to all who are familiar with the Madison Lecture, and that is that it would not have been possible without the enormous contributions across decades of our late colleague, Norman Dorson. He directed the Madison Lecture series for 40 years, from 1977 until his death in 2017. He was dedicated to the lecture as he was dedicated to the law school and to the law. Was our longest serving faculty member here at the law school, and his leadership of this lecture series, as I say, was just one of the many ways that he helped lead our institution over so many decades. We remember and miss Norman tonight, but continue this lecture series very much in his memory and honor. And so with that, let me turn things to our colleague, Professor Gillers, to introduce Judge Lynch.
Thank you, Trevor. So I was privileged to watch Norman introduce Madison lecturers of yore. It was quite a performance. He would find 20 people in the audience to personally introduce and tell an anecdote about, and it went on for a while. You sort of came for the Dorson introduction, and you might have forgotten about the lecture. That won't happen tonight. I cannot do what Norman did. We are grateful for your attendance. We cherish all of our Madison lecturers. Some we cherish a little more for particular reasons, and those in this instance are that Professor Lynch, Judge Lynch, still a professor, is an academic at heart, before going on the bench in 2000 and still. And so he comes back to a law school, not his home law school, but a law school in the same borough, in the same city. So the fact of the academic connection is a blessing because it merges the intellectual power of the Madison Lecture, where judges do get a chance to speak outside the traditional common law opinion writing framework, and because it brings a person who has never really left the academy to NYU Law School to speak. Judge Lynch will answer questions at the conclusion of the lecture, and then there is a telephone. And then there's some wine and cheese and what have you at the back after it's over. So I think now I'll leave the podium to Judge Lynch, and then I'll come back to do what is called closing remarks. I'm not quite sure what those are, but I'll think about them while he's speaking.
Well, thank you, Steve. At Columbia, we have faculty lunches where people present papers, and Henry Monahan used to be the one who gave the introductions, and his introduction was standardly, and now here's a person who needs no introduction and therefore will get none. So I very much appreciate the lack of encomia. I will say I am bilingual in academic and professional ways of thinking, though I've been on the bench for 20 years now, and I'm probably more comfortable in that dialect of law now. Okay. I'm honored to have been asked to give this year's Madison Lecture. I hesitate to single out any of the extraordinary predecessors at this podium. There are too many great judges to list and too much risk of slighting any. So I'll note only that the list includes both judges for whom I clerked more than 40 years ago, Justice William J. Brennan, Jr. And Chief Judge Wilfred Feinberg of the court on which I now serve. That long ago law clerk could not have dreamed of being someday in a position once occupied by those giants of my current profession, the art and craft of judging. That profession, that art, is under considerable pressure today. In the legal academy, there has long been a body of thought that sees the work of judges as a mere mask for the exercise of raw power. Increasingly, our political leaders act as if to reinforce the message of critical theorists, and their actions may help to turn that message from a theory into a reality. The press cannot seem to report the decision of a federal court on any matter without identifying the judges who made the decision by the political party of the president who appointed them. The general public, which has tended to rate the judiciary highest for integrity among the branches of our government, seems increasingly skeptical. And indeed, whenever I speak to non-lawyers about what judges do, their questions always seem to assume that when confronted with a question that touches on controversial issues of public policy, the role of the judge is simply to decide what's the best rule, by which, of course, the questioner means to reach the outcome that the questioner thinks is ideologically or politically correct. If politicians, editorialists, and law students seem to expect judges to decide cases based on their political preferences, judges speaking out in defense of judicial independence often take an opposite but equally simplistic tack, resorting to metaphors that, to the extent they signify objectivity, seem to strip judges of judgment, as if judges deciding difficult cases could be replaced by something like the K-zone computer that television baseball commentators use to critique umpires, or retreating to a set of formalistic rules that an informed but cynical citizen might note produce with suspicious regularity results that correspond to the policy preferences of one political party. It's not a good time for nuance and complexity, but for good or ill, nuance and complexity are what I have to offer this evening. I want to speak about a jurisprudential question that was a hot academic topic when I was a young lawyer. As I said, I've been away from full-time participation in the academy, so what I think is a hot topic is 40 years old. That question was whether there are correct answers to difficult questions of law. I caution that I'm not a professional philosopher of law, and so I approach this topic not from deep theoretical premises, but from the experience of many years of trying to make sense of concrete legal problems as a practicing lawyer and judge, as well as a legal academic. I want to advance two propositions in this talk. First, that there is indeed a class of questions, not insignificant in number, and including many questions that are important and politically salient, to which ordinary legal reasoning does not yield a decisively correct answer. And second, that the belief that there are absolute right answers, which can be reached only by applying a specific methodology, tends to devalue the importance of judicial judgment and to undermine the practice of judicial restraint, a critical value that can only have real bite in a world in which judges are acknowledged to be exercising judgment. The answers I will propose, I am afraid, are somewhat personal, and are rooted not in jurisprudential first principles, but in what it feels like, at least for me, to act as a judge. The debate over right answers was often formulated in my youth as one aspect of a debate between two formidable legal philosophers, the then established eminence H.L.A. Hart and the then upstart Ronald Dworkin, later to grace the faculty of this law school. Hart had contended that the system of rules created by legislation and precedent left a considerable number of questions open to judicial lawmaking, where the judge must exercise judgment and discretion. As he put it, quote, "At the margin of rules and in fields left open by the theory of precedents, the courts perform a rule-producing function, very like the exercise of delegated rulemaking powers by an administrative body." In contrast, Dworkin argued that this theory was inadequate and proposed what he contended was a better theory, quote, "that even when no settled rule disposes of the case, one party may nevertheless have a right to win," close quote. That disagreement was part of a much broader jurisprudential debate which long predates Hart and Dworkin and has continued in the decades since I first encountered it, concerning the relationship between law and morality. As I've noted, I'm not qualified to enter that broader debate. I want to address only the humbler question of how a working judge confronts the many questions that face him in deciding actual cases. In doing so, I want to suggest three propositions. First, that while most legal disputes can be resolved by identifying answers that are clearly correct under ordinary rules of reasoning, Hart is right that a significant number of important cases do not have answers that can be classified as right by applying those rules. Second, that one important reason for this conclusion is that the principles of reasoning that are sufficient to resolve most legal questions have exceptions and qualifications that frequently require the exercise of judicial judgment. And third, that the recognition that judgment is required in such cases is important to validating the principle of judicial restraint, while the effort to resolve cases by more mechanical rules can point to unrestrained judicial interventions in the political process. To start with, I need to define some terms. What do we even mean by a right answer? That's a fair question, though it's not one that unduly vexes the lawyer in her office facing a question from a client. My working definition of a right answer is purely functional, one that's by and large what a lawyer answering a client's question has implicitly in mind. What I mean is simply that the answer to a legal question is right when a lawyer asking the question can answer it with a solid conviction that a substantial majority of competent lawyers and judges would give the same answer and would find that answer essentially uncontroversial. Now, it can be objected that this definition prejudices Dworkin in the philosophical debate or begs the question he wants to answer. While he contends that the judge's duty is to decide, quote, what the rights of the parties are, not to invent new rights retrospectively, he quickly qualifies that by adding that it is no part of my theory that any mechanical procedure exists for demonstrating what the rights of parties are in hard cases, and that reasonable lawyers and judges will often disagree about legal rights. I don't purport to argue that my definition answers some philosophical question about what law is, or what answers are right in some absolute or abstract sense. My definition, however, is one I expect most lawyers would give, because it's born of the work of arguing points of law to judges, both from the advocate's podium as a lawyer and in conference rooms as a judge. In those very practical contexts, if I do not have an argument, not necessarily a purely mechanical one, but at least one solidly rooted in traditional lawyerly methodology, that will persuade a substantial majority of judges, regardless of their political persuasions or the party responsible for their appointment, then I do not have a legal answer that is clearly right. It doesn't matter to my client, who wants to know whether she can deduct the expense from gross income or whether he will incur liability if he takes a certain action, what a legal philosopher would conclude is ontologically the correct legal answer, or even whether the philosopher believes there is such a thing. If I cannot answer the client's question with some degree of certainty, there is, in the only sense that matters to the client, no right answer. There is at best an answer that comes with some degree of risk of turning out to be wrong. The same is true when I confront a question posed in appellate briefs by capable and conscientious lawyers. As I assess the case, there will often be at least some more or less plausible arguments made by each side. As I try to work my way to an answer, I am often thinking about whether the answer that seems most persuasive to me will likely persuade the other judges assigned to the panel that will decide the case. In a great many cases, the answer is clearly yes, that my interpretation of the governing statutory or contractual language, or my conclusion as to whether a cited precedent is controlling or distinguishable, is sufficiently solid that it will likely appeal to the others, regardless of whether they are Obama judges or Trump judges, Clinton judges or Bush judges. The answer is comfortably, if not unequivocally, right. I am not always correct in my prediction. Sometimes one of us may have overlooked some argument that renders the case more problematic. Sometimes one of us may be blinded by an unrecognized ideological presupposition that makes something seem very clear to that person, but that someone with a different set of political principles may see quite differently. But when I am confident of what the views of the panel will likely be, I am usually correct, and the result usually winds up being unanimous, regardless of the composition of the panel. But there are other cases where the legal materials seem to me open to divergent views. The lawyers on both sides present persuasive arguments, and even if I have a fairly strong view that one side has the better argument, I expect the case may produce different answers from different judges, sometimes for reasons that the general public would classify in political terms, sometimes just because the materials simply point in different directions. And I cannot be sure they will be assembled in the same way, even by a colleague with whom I generally share political or jurisprudential values. As a judge sitting on a court that operates collegially, it doesn't matter very much, any more than it matters to the lawyer counseling a client, whether I decide with Dworkin that my answer is right in some larger moral, political, or jurisprudential sense, or shrug that off as a question on which the court has discretion to act, to which my colleague's answer is more or less equally valid as mine. Each of us on the panel has to decide the case for himself or herself, and if we aren't unanimous about that, the side that gets 2 votes wins. Moreover, in a system of precedent, that result becomes, in any functional sense, the law, at least the law in our circuit, at least until and unless the Supreme Court or our court sitting in bank overrules the decision. Once the case has been decided, a lawyer advising her client in a closely similar situation can now give a definitive right answer to the legal question. That's what we mean when we say that the court has adopted a rule or decided that a given legal proposition is correct. If my panel is struggling with a difficult legal question, and we know that the same question is pending before the Supreme Court, we are likely to hold the case pending the Supreme Court's decision, because it's very likely that once that decision is released, our question becomes an easy one. I may shake my head and say that the court got the answer wrong, meaning I would have decided it differently, but there is no longer a doubt about the correct legal answer. Now, perhaps that description seems simplistic to the philosophically sophisticated, but that's the way law works, and all practicing lawyers and judges know it. Now, in terms of my definition, as the above discussion illustrates, it follows there are indeed right answers to most legal questions. That proposition will not surprise practicing lawyers, though it may surprise some first-year law students. Their surprise may stem partly from a theoretical commitment to some version of legal realism or critical legal theory, but it probably stems more from the quite reasonable preoccupation of legal education, particularly at the most highly regarded schools, with teaching students how to argue difficult legal issues. No one is going to pay lawyers top dollar to answer questions that any reasonably literate person can answer simply by reading the words of a statute or rule. It's better for our students to develop a facility for understanding how to decipher more problematic rules or cases. But the vast majority of legal questions that arise in most people's day-to-day lives are easy ones, and that is a good and necessary thing. For the most part, people should be free to go about their business with some confidence that their common sense, socially mediated judgments of how a person should act will accord with society's laws. We don't want people to need an expensive consultation with counsel before acting in ways that most people would find unproblematic, even when questions require a legal consultation. Because they depend on rules that are more specialized or technical, the answers will often be readily accessible to a trained professional. Our society would be in terrible shape if such questions as, what do I have to do to make an enforceable will? Or if I get a divorce, how will my and my spouse's property be divided, could not be answered at all, or if the lawyer could only say that it depends on whether you get an Obama judge or a Trump judge. Whatever shape you think the country is in, our problems do not include that one. Lawyers are typically able to answer the questions that their clients put to them, perhaps not off the top of their heads, but after carefully debriefing the client about the facts of the client's particular situation and doing some legal research. Now, that's hardly an original or controversial point, but it's worth making because an overbroad cynicism about law is sometimes expressed by members of the public or even by sophisticated legal commentators. Language is imperfect at conveying meaning, but it's not infinitely open-ended. Legal materials may be open to interpretation, but they are not infinitely malleable. Of course, even the cynics don't really mean all law. They mean only a certain category of legal decision, usually by the Supreme Court, usually in constitutional matters. It's often struck me that it's something of a disservice to jurisprudence that that's what jurisprudence concentrate on too, and not on the regular work of regular courts. So it's of some importance to realize that the basic bedrock of the law is not a matter of politics, but of reasonably clear rules that are capable of neutral application and are routinely so applied. It's also worth considering what a lawyer does to answer those easy questions. For the most part, the answer is indeed to follow certain formal, one could almost say mechanistic rules. Close reading of texts, the use of internal and extrinsic evidence to understand what their authors most likely intended to accomplish, and adherence to precedent using the common law tools of stare decisis and careful distinction of cases based on their distinct facts will produce reliable answers to most questions that come to lawyers' attention. But many cases that find themselves before the courts, and particularly appellate courts and especially the Supreme Court, are harder. Not most even there. There are economic and structural reasons why many cases, even in the federal courts of appeals, turn out to be one-sided, including the prevalence of pro se litigation and the incentives for some litigants, criminal defendants and others involved in cases with extremely high stakes, those pursuing grudges or matters of principle, get appealed even when the case has very low chances of success. But for the most part, lawsuits are filed and appeals pursued for economically rational reasons. Cases fail to settle and are pursued to higher levels when each party perceives a reasonable chance of winning. Sometimes one side is wrong in its calculations. But a great many questions that come before the courts are there because there are reasonable arguments on both sides. A judge approaches these cases very much the way a lawyer in her office would if a client asked her to answer the same questions. We do indeed first look for a simple mechanical answer. Read the governing rule or statute, consult the relevant precedents, hope, sometimes against hope, that a clear answer will emerge. I must tell you that most judges, and certainly this one, are very happy when it does. I don't sit in my office waiting for a chance to impose my policy views on the world. First of all, I don't even have policy views on most of the cases that come before me. Any federal judge must pass on large numbers of cases in which she lacks specific legal, let alone policy, expertise. On other issues, I have policy views that are good enough to serve me in the voting booth, where, like any citizen, I have to make decisions about candidates and issues based on the best information available to me and the best analysis I can manage in the time I can devote to understanding salient public debates. But I know full well that those answers are not sufficient to permit me to impose them, when my job is to decide as best I can what the law provides. And the volume of cases to be decided is such that judges will generally not have the time or energy to plumb potentially interesting questions to their depths. If the statutory language or a clear-cut precedent leads to an easy answer, I'm quite content to take it, whether or not I think I would have given the same answer if given absolute legislative power. However, in a great many cases, just finding out what the law is a demanding task, because neither statute nor precedents give consistently clear answers to the litigated questions before me. What's so difficult about them? Well, let's begin with texts. Although we still train students to assess the weight of precedents in a common law methodology, most legal rules today are to be found in statutes or regulations. And for the most part, the answer will be textual and based on something that a lawyer will likely call plain meaning. Again, this shouldn't be surprising. The law is made up of words. Law can be described as the effort to control people's future behavior by means of words. Some laws are addressed to the public, some to specialized segments thereof, and some, in effect, only to judges and public officials. A lawgiver, usually the legislature, makes a rule to govern some anticipated or recurrent situation, a rule that tells people what to do the next time that situation arises. For the most part, the statute is going to tell us what to do, hopefully rather clearly. But the text does not always offer a definitive answer. We all owe a debt to the late Justice Scalia for recalling us to an insistence on the text as the first and most important source of statutory meaning. Surely the effort to control behavior by written laws is hopeless if courts will ignore or resist what legislators have conscientiously tried to make clear. But words can be slippery, as we well know, and not every law is competently drafted even to address its core concerns, let alone unanticipated variations. And as any lawyer who has ever drafted a contract can attest, no one has perfect foresight of all contingencies that can arise. A text, may be drafted effectively to give a clear answer to the question that provoked its adoption, but that language may turn out to be quite ambiguous as to its effect on unanticipated situations. And even when a law is not, strictly speaking, ambiguous, the text may give an answer that a reader may have considerable doubt was intended by the legislature. Sometimes the legislative history may give us a pretty good indication of what was intended by the language that was adopted. Again, we owe a debt to Justice Scalia for pointing out that legislative history must be used with care. Sometimes statements are inserted in the congressional record that were never actually spoken, or they may have been crafted strategically by the member, her staff, or lobbyists for the very purpose of influencing a future court. All of that is true, but it is not the only or even the dominant truth. As Chief Judge Katzmann has reminded us in his powerful insider's account of how Congress actually works, the claim that the words of a statute are sacred because that is what the legislators actually voted on is an oversimplification. To the contrary, in many instances, the legislators and even their staffs may have relied heavily in deciding how to vote on committee reports describing the content of bills rather than on the dense and sometimes technical language of the bills themselves. Legislative history can be illuminating, even of texts that may seem to point emphatically in only one direction. Moreover, even in the absence of legislative history, the text sometimes seems to point to answers that are highly questionable, both as a matter of policy and as an understanding of what the legislature was really trying to accomplish. And by that, I don't mean simply cases in which the result dictated by the text is, to use the favorite formulation of plain meaning adherents, absurd. Whatever the rhetoric of politicians, editorialists, and judicial nominees at confirmation hearings, courts with some frequency confront texts that, taken literally, will lead to results that seem unlikely to have been intended by the legislative majority. And when you look at cases as they are actually decided, rather than the political rhetoric, that truth is not really a matter that divides liberals and conservatives. I have time for only one extended illustration. I'm going to try and condense it in the interest of time. Consider United States against Excitement Video Incorporated, which was decided by the Supreme Court in 1994. The case represents a good example of something courts are often called upon to do, to make sense of a statute that probably did not anticipate all possible applications. The statute was the Protection of Children Against Sexual Exploitation Act of 1977. As the name suggests, this is a statute whose basic purpose enjoys universal support, which is sometimes dangerous because universal support for a policy goal may lead legislators to overlook certain nuances of application. The specific issue in the case was whether a provision of the statute that prohibited the distribution and interstate commerce of child pornography required for conviction that the defendant knew that the film or photo that he transported contained child pornography. That is, that they depicted actual minors engaged in sexual activity. The language of the statute, read in light of ordinary English grammar, quite clearly does not require such knowledge. The word knowingly does appear in the statute, but it appears in an entirely separate clause from the one referring to the involvement of minors. And indeed, the somewhat awkward structure of the provision may appear to avoid a more straightforward statement that would have made it easy to read the contested knowledge requirement into the statute. The statute might have said, whoever knowingly transports a visual depiction of a minor engaged in sexually explicit behavior, and if it said that, it would be rather easy to read the word knowingly as applying to all of the elements that follow, such that to be guilty, one would need to know that one was transporting something in interstate commerce, that that something was a depiction of sexually explicit behavior, and that one of the persons engaged in the behavior was a minor. But instead, it punished any person who knowingly transports in interstate commerce any visual depiction if the depiction is of a minor engaged in sexual activity. The location of the minor in the if clause isolates it from the verb knowingly. In ordinary English writing, the word knowingly cannot apply to the presence of the minor. And that is exactly what Justice Scalia argued. But he lost, and the loss was not close. The vote was 7-2. The opinion was written by Chief Justice Rehnquist, certainly not a judicial activist or liberal. Why? The core of the majority's reasoning was that to read the statute, according to what Justice Rehnquist acknowledged was the most natural grammatical reading, would require the conclusion that Congress chose to punish criminally someone who knowingly transported a particular package of film, whose contents were unknown to him, but which turned out to include images of child pornography. The Chief Justice and 6 colleagues thought that a troubling result. Now, I'm not here to disagree with the result, or to argue that it lacked a firm basis in judicial reasoning. Chief Justice Rehnquist identified 3 principles of statutory interpretation that enabled him to escape from a literal reading of the statute. The principle that statutes should not be read to require absurd results, the presumption that criminal statutes contain mens rea or scienter requirements, Latin phrases meaning essentially wrongful intent, and the principle that statutes should be interpreted to avoid constitutional questions, quite conventional legal reasoning. But note, as Justice Scalia's refusal to join the opinion tells you, they are not strictly textualist reasons. They are not independent of the majority's policy preferences, and they do not involve a simple matter of calling balls and strikes. As for avoiding absurd results, absurdity is in the eye of the beholder, depending on a wavering line between results that are merely odd or undesirable and ones that are truly indefensible. Moreover, that line rests on judgment of policy or principle, drawn from substantive values. The principle that criminal punishment ordinarily depends on a guilty mind is a commonplace for criminal law scholars and is second nature to lawyers. But legislators who have not been exposed to those principles may well prefer, where they believe it is important to achieve strong deterrence of certain conduct, the idea of strict liability. If you're going to transport pictures in interstate commerce, you are responsible for avoiding child pornography at your peril. Such statutes have been consciously created by legislators and upheld under various circumstances by courts. To pin the label absurd on the consequences of strict liability is mostly to say that the court thinks that the legislature in this instance should not have, or perhaps would not have if they had thought about it more deeply, decided that the unfairness of punishing the morally innocent outstrips any social benefit that can be produced by strict liability. The presumption against reading at least the more stringent types of criminal statutes to impose strict liability is well established in our law, but it is not ancient, and it's not really a very good guide to deciding what the legislators who voted for it actually meant. It was devised by the great Justice Robert Jackson in Morrison against the United States in 1952, putting a brake on a run of cases in which the court had read various modern or regulatory criminal statutes as creating strict liability. In one of the great feats of judicial sleight of hand, Justice Jackson found a common law intent an intention required for the classic common law offense of larceny in a federal statute that did not explicitly incorporate it, on the ground that Congress probably failed to include it because it's so familiar to lawyers that it went without saying. But if Jackson's rule was a well-established precedent in 1994, he pretty much made it up when he adopted it for a unanimous court in 1952. He certainly wasn't calling balls and strikes or reading the plain text of the controlling statute. And if we say that the court in Excitement Video was relying on a precedent about how to read statutes, the very existence of precedent as a complicating factor tends to undermine strict textualism. Read it for the plain meaning, at least in some cases, is a rule that will produce a predictable balls and strikes outcome, albeit one that might not be desirable. But read it for plain meaning, unless precedent counsels otherwise, is much less predictable, given that precedents are even slipperier than texts themselves. And in fact, Jackson's case did not require him to rule that all criminal statutes should be read to include a mens rea element, and he didn't say that they should. He distinguished statutes that codified long-standing common law crimes, had severe penalties, and addressed conduct that was wrong in itself, for which mens rea would be presumed to be required, from innovative statutes that had lowish penalties and prohibited conduct on the basis of regulatory policy rather than basic morality. The child porn statute, heavy penalties, aimed to control conduct that most people would consider immoral, but it was not a traditional common law crime, and a law prohibiting the mere transportation of pornographic images might be seen as a regulation of the mails and the internet rather than the equivalent of, say, statutory rape laws that would prohibit the producing of such images by inducing children to engage in sexual activity and filming the result. Is Jackson's presumption of mens rea triggered? Maybe, maybe not. It requires a judgment call. At the heart of Excitement Video is a violation by Congress, perhaps an inadvertent one, of what to judges is a strong principle. Again, I have no quarrel with the principle or its application to this case. I agree with the principle. I expect that most people, if they thought about it, would agree both with the general presumption and with the fact that the statute should have complied with it. My point, rather, is twofold. First, that this is a policy judgment, and it's one that, quite as much as the belief that people should be allowed to marry someone of the same sex if they choose, relies on a principle perhaps more commonly understood and believed in by elite judges than by the lay public. And second, that even conservative judges will commonly exercise judgment based on that kind of policy conclusion, even in the face of apparently clear language. If I had time, I could cite many similar cases. I'll just briefly mention one, last term's United States against Davis. The issues in the case are sufficiently complex that I'll just refer you, if you're interested, to the CLE materials, with the observation that in that case, the plain textualist reading prevailed, but did so by a bare 5-4 majority. The 4 justices in dissent, well-known liberal activist judges, were Chief Justice Roberts and Justices Thomas, Alito, and Kavanaugh. who wrote the dissenting opinion. The dissenting justices would all, I'm sure, in general terms, embrace some version of textualism and plain meaning. It was Chief Justice Roberts who famously voiced the balls and strikes metaphor at his confirmation hearing. Justice Thomas joined Scalia's rigidly textualist dissenting opinion and excitement video. On the other hand, Justice Gorsuch, writing for a majority that included the court's 4 liberal members, derided the dissent in Scalian terms for relying on intuition, in quotes, about how ordinary citizens might read the statute to conclude that the majority's reading was unnatural. My point is not to snipe at various justices for any perceived inconsistencies of approach. My point, rather, is that there is more that goes into judging than a mechanical formula can capture. In both of these cases, as in so many others, a substantial number of justices, including justices who have been touted by themselves or others as strict constructionists, rejected the most literal grammatical reading of a clear statutory text. In my view, the intuition that Justice Gorsuch criticized is in fact the exercise of judgment. The cases were genuinely close, notwithstanding the literal text, because there were strong arguments that the consequences of following the literal meaning gave significant pause about whether doing so would be undesirable as a matter of policy, made it doubtful that Congress understood the consequences of a literal reading, and because there were legitimate, albeit not strictly textualist, arguments available in the legal tradition that give judges a basis for reaching a result inconsistent with such a reading. In each case, what was called for was a weighing of those arguments, and not simply a mechanical application of simple formula. It should not be surprising that deciding such a case can easily divide 9 reasonable people committed to pursuing correct legal outcomes, not always strictly along party or even ideological lines about the best answer. At the same time, the exercise of judgment necessarily draws to some degree on a judge's principles and life experience. I don't think it's an accident that the textual argument in Davis, which was strong, though perhaps not as strong as the textual argument in excitement video, prevailed with justices who were skeptical of incarceration. The case wound up declaring unconstitutional a statute that had imposed very stringent mandatory penalties on people who used guns in connection with certain crimes. The justices who were skeptical of incarceration, the 4 supposedly more liberal justices, and Justice Gorsuch, a supposed conservative with a libertarian streak who's skeptical of the expansive reach of federal law enforcement, decided on an interpretation of the statute that under prevailing Supreme Court precedent made it unconstitutional. That argument was unappealing to a group of justices, including 3 former Justice Department lawyers, 2 of them experienced prosecutors, should also not be surprising. Professor Dworkin recognized that different judges with different backgrounds and philosophies would reach different conclusions about the right outcomes in legal cases, even if they all applied the complex methodology that he proposed in place of a mechanical approach. But with all due respect to him, I think it is a very special gloss on the word right to contend that there is an answer that is right as a matter of law, not just ideology or political values, where the answer that individual judges decide is right is ultimately dictated by their individual balancing of factors that include policy judgments and that could not easily be predicted in advance based on the application of purely methodological rules. In my limited time tonight, I can't go on to give similarly, I'm probably glad to give similarly detailed examples of why other techniques for reaching right answers, which work well on many cases and form the grist of ordinary legal analysis, will not always point to a clear answer. Take, for example, the principle of stare decisis, more Latin, this time meaning, of course, that a court's precedents must be followed by the same court or those directly inferior to it in the judicial hierarchy. As a result, we have case law. Case law is trickier than statutory law because there is no canonical text to be read. The judge must follow the same principles laid down in prior cases, not because the words of an earlier judge's opinion are authoritative, but simply in order to ensure that like cases are decided alike. Attention will be paid to what the prior court said about why it was deciding the case, but the words are less important than the facts of the case, and later courts can reconcile a decision that might depart from an earlier formulation of a legal rule by distinguishing the next case, that is, by explaining why the decision now being rendered is fully consistent with the actual result in the prior case. Again, many legal rules are authoritatively settled, at least for the moment, by the decision of an appellate court. That's why the news media, or even we judges, will often say something along the lines of, in a closely watched case, the Supreme Court today settled a question that had divided courts and patent lawyers. Before the court decided the case, the question was unsettled by my definition. But now, a lawyer can give a definitive answer. There is now a right answer in my functional sense. The parameters of the new rule may leave some or many applications uncertain, but ordinarily the decision will settle not only the precise question before the court, but will give sufficiently clear guidance on how a range of related questions should be decided. But I don't think I need to analyze examples to convince an audience of lawyers that the process of applying precedent is highly malleable. Arguments about whether a precedent can be distinguished are the grist of thinking like a lawyer from the first day of law school to the last or most important case of any litigator's career. That doesn't mean that any outcome can be squared with any precedent. Lawyers will often agree that a given precedent can't be squared with one side's position in a case. But it seems to me that that conclusion is almost always based on general acceptance, even by those who might like to see change, that the political or social value judgment lying behind the precedent represents the prevailing conventional wisdom of the political classes of society. Perhaps at some future point, the precedent may be chipped away by distinctions and exceptions to the point that there is a respectable, perhaps even a winning argument that it should be sharply confined or even overruled. And in some number of cases, there will be a strong but still contestable argument that the situation before the court is simply distinguishable because the case presents different facts and policy considerations than those that produced the precedent. While stare decisis counsels against overruling precedents, courts do remain free to do so, and that is almost always a question of judgment. As Justice Holmes reminded us, time has upset many fighting faiths, and in the same way, time has upset many well-established precedents. Indeed, sometimes it doesn't even take much time. In Jones against Opelika, a decision upholding against First Amendment challenge, Jones against Opelika, a decision upholding against First Amendment challenge the application of a tax on door-to-door soliciting by Jehovah's Witnesses, was overruled by the Supreme Court less than a year later in Murdoch against Pennsylvania, in time for the judgment on the original case to be vacated on re-argument. Today, it seems that every case in which a Supreme Court precedent is called into the slightest question, both the justices and the commentators engage in fencing about the weight to be accorded to precedent, a debate that many view as preliminary skirmishing over whether Roe against Wade may be overruled. But a glance at the cases in which the court has overruled precedent or has conspicuously decided not to overrule a precedent makes clear that an exercise in judgment is involved. Even when justices believe that a prior decision was wrong, the pull of precedent will most often lead to its being left in place, and the decision to overrule balances some conclusion about just how wrong the prior decision was with a host of discretionary factors, including the extent to which, as Chief Justice Rehnquist again put it in declining to overrule Miranda against Arizona, the extent to which the case has become, quote, embedded in routine police practices, close quote. One may strongly believe that overruling Roe would be the wrong thing to do in any number of senses of the word wrong, but I don't think there is any simple or mechanical test that would allow one to decide that overruling any particular precedent is clearly right or wrong as a matter of the law of stare decisis. I don't need to say much about originalism in constitutional interpretation either, in part because the main things I would have had to say about it were said beautifully and persuasively by my Columbia colleague Henry Monahan. In a 1988 Law Review article, Professor Monahan pointed to a paradox about originalism. While originalism, like textualism, attempts to provide a methodology that is objective and independent of policy preferences, the fact is that the courts have departed significantly from originalism, not just in a few minor or aberrational cases, but in cases such as Brown against Board of Education that are not only accepted parts of the fabric of our law and society, but are regarded as vital decisions that help keep the country on a viable path. As Professor Monahan pointed out, Brown is not going to be overruled. Not only that, but the current constitutional debate about issues like affirmative action is played out not with reference to what the drafters or ratifiers of the 14th Amendment might have thought about those issues, but with reference to which vision of equal protection of the laws is more consistent with the principles of Brown. Professor Monahan's article derives its power not by articulating arguments for or against originalism as a matter of principle of interpretation based on basic ideas about legitimacy, but rather from a recognition that even for a defender of a strong role for original intent in constitutional theory, as Monahan is, the practice of stare decisis, not simply as a tool of legal analysis, but as a fundamental fact about the evolution of a legal system and a society, requires courts to abide for the most part by settled law. That practice serves purposes similar to those served by originalism itself, as a constraint on judicial decision-making and a foundation of a stable society under law. Uprooting expectations and conceptions of justice derived from Brown would be an unthinkable disaster, not only because Brown's principle is just, not only because it represents a commitment to racial justice that is, in a deep sense, part of the bedrock meaning of equal protection of the law, but also because it is there, and we have staked our society on it. I would add only two thoughts on this subject. One is there's an inherent tension between the discipline of history and stare decisis as a legal principle. The problem is that history as a field of scholarship is constantly in flux, open to new interpretations based on new evidence and new paradigms of thought. It's not just that lawyers and judges aren't trained to be good historians, though we aren't, or that the kinds of histories on which we draw to interpret the Second Amendment or the Equal Protection Clause are often tendentious arguments crafted to support a preconceived legal position, though they sometimes are. It's that good history is always up for grabs, while for the most part, law requires that the conclusions we draw today will be settled law indefinitely into the future. Of course, it's possible for precedents to be overruled. Brown itself overruled Plessy against Ferguson, which had been the law for over half a century. But that will happen when the precedent no longer fits social needs, and it won't or shouldn't happen simply because a young historian just wrote a Bancroft Prize-winning book that challenges the previously accepted historical consensus. In the years since the earlier precedent was decided, a superstructure of law may have been built upon it. Tearing that structure down is unlikely to be desirable, even if a novel historical analysis reveals that the original foundation of the structure was flawed. The second point, as Professor Monahan recognized, is that once it is established that a decision like Brown departed from the original intent of the framers and ratifiers, and that we are profoundly grateful that it did, the very foundation of originalism must be shaken. We might, with Professor Monahan, want to establish a kind of presumption that courts should not readily depart from original intent, at least as to the broad concept or principle behind the words, and at least where that intent is discernible. But if there are exceptions, a judge must ask herself, how do we know whether the current case is one of them? Perhaps judges will be too quick to mistake their own fallible policy preferences for the kind of basic principle that a half century and more hereafter will look incontestable and make the judge a hero of history for having recognized the occasion. But there's also the danger that judges will miss the occasion and will hew too closely to original intent when the moment for another Brown is upon us. Into which category do we place Roe? Furman against Georgia Obergefell versus Hodges, District of Columbia versus Heller? More relevant to the question of judicial judgment, into which category would a judge have placed any of these decisions, or for that matter, Brown itself, ex ante, as the judge is faced with arguments that the original intent of the framers points one way, the lessons of history since the framing, and the current needs of society point another? Let me return to Hart and Dworkin. As I've already suggested, it seems to me that Hart has the better of the argument insofar as he recognizes that the role of the judge is not confined to identifying a correct legal answer. At least in the sense that matters to lawyers and judges, there is not a clear right answer dictated by legal methodology in many controversial cases. Legal methodology is too diffuse. Original intent jostles with stare decisis, textualism with respect for the purposes of the legislature. Sometimes all or most of the relevant factors line up to point in the same direction, and we can be confident that the law dictates a particular answer, even where the judge she appointed as the ultimate lawgiver would have adopted a different rule. But cases are litigated and hard cases are hard precisely because the jostling methodologies sometimes don't point in the same direction, and judges still must decide those cases. But Dworkin, too, had an important insight. It is not enough to say that judges have discretion to fill the gaps in the law with their decisions. Judges can't just say, well, there's no clear answer here, so I will answer the question according to what I think would be a good rule. That's not to say that the judge's policy views are irrelevant. A judge should certainly hesitate where the legal materials yield no clear answer to adopt what she is confident is a bad rule, but we want a judge to do more than vote for his or her preferred policy. Dworkin argued that the judge must construct a conception of the legal order that is coherent and just, and then decide individual hard cases in a way that best advances that conception. There's some truth and some value to that formulation. A judge is always looking to root her answers to hard cases somewhere in the legal tradition, somewhere external to her own policy views. But it's far from clear that there is a single overarching set of principles that genuinely drive our legal order. The legal order is a hodgepodge of decisions made at different times for different historical reasons by different actors facing different problems in different eras, applying different ideologies. How can we make unified sense of the compromises and shifts in direction that mark our history? In the early 19th century, some abolitionists, like William Lloyd Garrison, believed that the United States Constitution was not merely flawed, but was inherently a pact with the devil that enshrined slavery, and must therefore be entirely rejected by anyone with a true sense of morality. Others have argued, including recently the historian Sean Wilentz, that the original Constitution actually did about as much as could be done politically at the time to undermine slavery. And whatever we think the 1787 Constitution had to say about racial justice, between then and now, we have had a civil war leading to the abolition of slavery and to what many reformers then and now thought was the birth of a new, more just republic embodied in the 14th and 15th Amendment, followed by a retreat from that vision. With the end of Reconstruction, the Supreme Court's abandonment of civil rights in cases like Plessy, the onset of terrorism and lynch law in the South, nearly a century of Jim Crow and racial subjugation, followed in turn by a revival in the mid-20th century, led by thinkers and activists like Martin Luther King, of the vision of equality argued in the mid-19th century by Frederick Douglass. Is there really one vision that we can agree represents the meaning of such a contested and convoluted history? And in the absence of plausible agreement, as Dworkin effectively recognizes, any given judge's construction of the overall path of the law will only be that judge's own view. But a more modest version of Dworkin's approach does offer some guidance to the judge in search of answers. If legal materials point in different directions, there may well still be at least a persuasive argument in a particular case that the weight of some materials is greater than that of others. Similarly, if the arguments for textualism and stare decisis don't generate a formula as simple and authoritative as senators seem to want judicial nominees to pretend exists, that doesn't mean they lack all value. What is called for is an exercise of judgment about the specific weight to be given to particular pieces of evidence in particular cases. The text is the starting point, but I don't think we have to wait for cases in which the text yields an answer that can be called absurd to decide that we are pretty sure that the legislators who drafted and supported a statute or constitutional provision did not intend a particular result. Not simply that it did not anticipate a particular result, but that it and the public who voted for the legislators who voted for the law would never have adopted the general principle for which a litigant contends the text stands. I started with the fear that my thoughts on these issues would seem philosophically naive. I end with the fear that my practical focus may not be terribly practical. To say that careful judgment is called for is not very helpful in deciding how actual cases should come out. But the recognition that the exercise of judicial judgment yields contingent answers rather than answers that are simply correct has two valuable results. First, it gives a more realistic understanding of the nature of judging and of the role of the judiciary in cases that deeply divide the public and elected officials. And second, it softens a certain judicial arrogance that comes with the belief that one's own conclusions about a case, however derived or however one purports to derive them, are emphatically right to the exclusion of other answers. These two results are important and they are intertwined. First, just as it is important to understand the limits of what Chief Justice Roberts could possibly mean by saying that a judge's role is just to call balls and strikes, it is also important to understand the limits of what he can possibly mean by saying there are no Trump judges or Obama judges. As I've made clear, I think that judges in all cases are looking for objectively correct answers, and in a great many cases, we can find them. In cases where there are reasonably clear right answers, litigants can be quite confident that neither their or the judge's political convictions or former party affiliations will make a difference to the outcome. Moreover, I hope it is true, and my experience watching judges at work, both as a lawyer appearing before them and as a colleague and participant observer, suggests that it is, that judges are not influenced by whether a particular result will advantage a particular politician or political party. But once it is recognized that the answers to a fairly large number of significant legal questions are not dictated by a simple methodology, and that good arguments can be made for both sides, not simply because lawyers are clever sophists, but because in some matters the legal materials are indeterminate and the decision calls for an exercise of judgment, it becomes clear that the judge's overall philosophy can make a great deal of difference. This is true even at a very mundane level in ordinary civil cases of the kind that rarely, if ever, get the attention of the Supreme Court and that are indeed decided by settled law. There's still considerable room for the exercise of judgment. In the majority of civil cases, judges are called upon to decide whether a complaint states a claim for relief, and at a later stage of the case, whether there are genuine issues of material fact for a jury to decide. The drafters of the Federal Rules of Civil Procedure in the 1930s saw a very limited role for these procedural mechanisms, the motion to dismiss under Rule 12b-6 and the Rule 56 motion for summary judgment. The former was intended for cases that presented only an issue of law because the facts were essentially agreed upon, and the latter for cases in which, after wide-ranging discovery, one side could identify no evidence that would permit a jury to decide the case its way. But the pressure of expanding caseloads led the Supreme Court to expand the role, first of summary judgment in the Celotex cases of the 1980s, and then a generation later of the motion to dismiss for failure to state a claim in Twombly and Iqbal. Today, deciding these matters is a matter of judgment and discretion. Deciding whether a complaint contains, quote, sufficient factual allegations to be plausible, close quote, is very different than deciding merely whether a complaint alleges in general terms a legal claim. Deciding whether a reasonable jury can make a fact finding on a particular cold record is very different from deciding whether there is simply no evidence to support one acknowledged element of a plaintiff's claim. These are now judgment calls. On such questions, judges who are generally skeptical of whether the value of litigation exceeds its costs will surely apply the standard differently in particular cases than judges who believe that litigants should generally have their day in court. Thus, more open-ended standards for deciding pretrial dispositive motions are likely to generate different outcomes depending on whether the judges are appointed by Democrats or Republicans. And what is true in these mundane applications is true in deciding large and controversial questions of statutory interpretation or constitutional law. That is not a terrible thing, nor is it terrible that judges with different substantive political philosophies are likely to see close judgment calls differently. That is a feature of the system, not a bug. It's what makes Alexander Bickle's famed counter-majoritarian difficulty less of a bogey than it was painted. Because judges are appointed through a political process that vets their ideas and principles as well as their lawyerly skills, over time, the public should have its way, and a Supreme Court that is consistently at odds with the values of the people will change over time with the results of democratic elections. Footnote, this presumes that elections are democratic. This presumes to some degree that judges don't select, presidents don't select judges with a view to how young are they and how long will they be able to continue to sit on the Supreme Court, and there's some reasonable turnover in judges. But if there were no such thing as Reagan judges or Roosevelt judges, the body of Supreme Court case law would look decidedly different than it does. Second, a recognition that the appointment of judges has and is intended to have political effects, and that the open texture of at least an important subset of legal rules opens the door to varying interpretations of texts and precedents, should temper the views of both politicians and judges. This is getting a little idealistic. That understanding might help the public, the press, and politicians to learn that judicial decision-making is not a matter of one side following a legitimate judicial philosophy and the other being unscrupulous or hypocritical. It's simply that differences over the proper construction of legal materials are inevitable, and that judges' own values, in some sense of that phrase, will play a role in deciding hard cases. In this area, as in many others, damping down the rhetoric would be helpful. That recognition should also lead to a measure of what has been called judicial restraint. As Professor Bickle also taught, the openness of legal reasoning suggests that the proper exercise of judicial judgment calls for judges to be cautious about their use of the Constitution, and I would add about their interpretation of statutes and their application of legal standards calling for the exercise of discretion. I can hear the skeptics saying, aha, liberal judges, politicians, and editorialists have discovered the values of judicial restraint now that they don't have a majority on the Supreme Court. There's no doubt some truth to this, just as there is truth to the reciprocal charge that former advocates of judicial restraint now seem perfectly happy to have judges overrule longstanding precedents and strike down acts of Congress based on vague constitutional texts once the judges' interpretations of those texts correspond to their political preferences. I ruefully acknowledge that over the long ascendancy of a more politically conservative Supreme Court, I have sometimes felt that I now understand what lawyers and judges educated in the 1930s must have felt as they read decisions of the Supreme Court in the 1950s and 60s. But other experiences have educated me in that direction as well. As a law student, I was not much persuaded by my teacher's questioning of the ability of judges to manage institutions like prisons through injunctive relief resulting from law reform litigation. I must say that the experience of presiding over prison conditions litigation pretty quickly led me to understand what my professors were talking about years before, and grappling with both the practical problems of such cases and the daily grind of deciding all difficult cases, particularly in collaboration with judges of strong intelligence and legal skill, but very different political and jurisprudential assumptions and premises from my own, have given me a different perspective on legal issues that can seem very clear to those who do not have to grapple with the actual records of discovery and trial, the actual textual material day after day across a wide variety of legal specialties. The recognition that there is not one method that will always yield unanimous answers, or for that matter, that will yield consistently just outcomes, is humbling. And humility is an especially valuable virtue for judges. A belief that one is simply pursuing a strict objective methodology can lead to a willingness to overturn the judgments of one's predecessors and of the political branches just as much as a belief that one is entitled to pursue one's own vision of justice from the bench. The title of this lecture is Complexity, Judgment, and Restraint. I was asked by the organizers to put a colon after that title to be followed by a more descriptive subtitle describing what the lecture was intended to be about. You know how law review articles and popular books have. But I like the title because it summarizes my thesis. The law is complex. Navigating complexity leaves room for discretion and thus requires the exercise of judgment. The power to exercise one's own judgment, however, in matters affecting the governance of a democracy, in turn entails some sense of caution and restraint. And with that, I thank you for your attention. By the way, I recognize that was longer than I thought it was going to be, but people who know me know that I have trouble answering a yes or no question in an hour, so I thought I did pretty well.
So Judge Lynch has agreed to take questions from the audience. There are microphones on either side, and if anybody wants to ask one, you can go up to the microphone and do it. Can you just
Judge Lynch, you mentioned,
state your name and ask your question?
yes, you mentioned, well, the case that overruled Conley v. Gibson, or the two cases, we call them Twombly, or Twickball, Twombly and Iqbal. Do you feel that that was a relief act for the federal courts? Do you feel that that gave the federal courts an out to get rid of cases?
Is this on?
Yeah.
Yeah, okay. Yes, actually. I think it's caseload pressure that does it. And the same was true of Celotex and the expansion of summary judgment. When I was a district judge in the Southern District, I got 25 to 30 new civil cases every month. That doesn't include the criminal docket. That means that if the backlog is not to grow, 25 or 30 cases have to close every month. You can't try 25 or 30 cases in a month. Usually, if you can try 3, that's a pretty impressive month. So there do need to be ways of weeding out cases. This, too, I mean, I wish in some ways it weren't the case. On the other hand, the polity decides how much money to devote to resolving civil disputes. We do a lot of other things with the money. We educate, we do healthcare, we do wars on many continents lasting for many years. Somebody has to decide how much money is going to go to the courts, and it can't be unlimited. We can't have a society where a third of the people are judges and the other 2 are suing each other. So they decide how much money to give us, and at some point something's got to give. Lest, the law's delay drove Hamlet to think of suicide. It's one of the things on his list of the problems of life. We should be able to dispose of cases. But again, this is going to lead to more exercise of judgment by judges at the expense of, say, juries.
Thank you.
I have a question, Judge Lynch, and maybe you want to answer this hypothetically, and maybe I shouldn't be asking it. But Obamacare legislation is in the Fifth Circuit now. It may go back to the Supreme Court. It's a hard case. Are the interpretive tools available to the circuit or the Supreme Court in this challenge, this latest challenge, do those tools legitimately include, forgetting for a moment how they would point, the consequences to the 20 million people insured under Obamacare of declaring it unconstitutional or illegal or a violation of something?
Well, I'm glad the case is in the Fifth Circuit, and I have enough trouble deciding the cases that are before me. But in the abstract, I would say yes, of course.
They can consider.
I think so, yes. And I think the same was recognized to some degree by Chief Justice Roberts in the first Obamacare decision that upheld most of the act. Practical consequences have meaning. But it's not just a question of, I mean, that's different though than to say that, oh, a court could decide, just like out of the blue in some insurance case, that from now on, everybody is going to be covered by federal health insurance, Medicare for all by judicial decree. It's a very different thing to consider those consequences when you're looking at a statute that was passed by Congress that represents a significant political decision and a significant degree of compromise by different factions. To ask yourself, I think you'd have to think that that was really amazingly unconstitutional before you strike something like that down.
Questions at the mic? Oh,
Yes, I think
Yeah.
it's working. Good evening, Judge Lynch. I'm Nelson Stern from the class of '89. You mentioned that in most cases that the outcome is relatively to be expected, but how would you apply that to the Citizens United U.S. Supreme Court decision, which seemed to be very creative and out of left field, the way it classified corporations as citizens?
Well, I think I said most cases, and I'm not sure what percentage I would say that is, between 50 and 90, but a majority of cases are easily decided, and there's a consensus about. But it's also true that many cases are difficult cases. It's also true that judges sometimes innovate, and that cases are surprising sometimes in their result. Citizens United was one, but I think to some degree so was Roe. Certainly was Furman against Georgia, where the Supreme Court just a couple of years before had failed to strike down the death penalty on procedural grounds. And I have theories about why it happened, but the court turned around and using the Eighth Amendment rather than the Due Process Clause suddenly said the death penalty is procedurally unconstitutional. So all kinds of things happen in what courts do. And I think there are some cases that one could say, this is really weird and strange, and I don't like it, and I think it's really so inconsistent with basic legal reasoning that it should be wrong. And you can take your pick, whether you put Citizens United or Roe against Wade or something else in that category. But I don't think it affects my basic thesis that, for the most part, ordinary litigation comes out in ways that good lawyers can usually predict. Footnote. The problem is good litigation happens when that is not the case, when lawyers have reasonable positions to take on each side. And I think we have to consider ordinary litigation as well as mega Supreme Court cases in deciding how our judicial process works.
I think
Thank
we have
you.
time for one more question, if there is one, and here it is.
May I? Hi. We're colleagues of a sort. I'm a district judge or an appellate judge.
Definitely colleagues.
But you used to have my job, and my
Yes.
question is, how have your views changed and evolved, if they have, since you have been on the appellate court? And could you have given the same speech when you sat on the district court?
Yeah, I think so. That's a good question, an interesting question. I think the change is more from being a judge versus things I used to be. I think I've become much more restrained in my thinking about what judges can and should do from the experience of doing it. I will say one thing that's different on the Court of Appeals. On the district court, you have much more power, actually, over particular cases. You're nodding when I see. You know, the way the case comes out is much more strongly influenced by what an individual judge does. Now, that may not be the same thing as power to make law over such mighty places as Connecticut, Vermont, and New York, but it is an enormously powerful position. The vast majority of what district judges do is never going to be reviewed by anybody. The decision is made, it influences how the case is going to be settled, the case then settles, the Court of Appeals never sees it. Lots of decisions are made by a district judge on a daily basis in a litigation that goes on for years, and then even if it's litigated to the end, some clever appellate lawyer picks out one little thing that you did and makes that the centerpiece of the opinion. You think that's what this case is now going to be about? But what is different on the Court of Appeals, it's a collegial operation. I don't mind being 1/3 of a judge. There are certain values to that. I like not having the full responsibility. I like when I get one of these difficult cases and I think, boy, here's where I come out. I wonder if anybody's going to agree with me. And then it turns out that 2 other very smart people do. Then you feel really good. Or maybe 2 other very smart people feel completely the opposite. And sometimes you think, what's wrong with them? But other times you think, well, you know, I'm probably not right. I mean, you know, I was 51% this way. They seem very certain it's the other way. And I think that's a helpful thing in thinking about how that works. Now, footnote, I think 3 is a better number than 9. I hate en banc decisions. My sense of the en banc process is it's like a legislature. You sit there and you're tallying votes as each person speaks. And, you know, whereas when it's 3, you're actually talking to each other. And that can often lead to a much more complex and thoughtful decision. I'm not sure once you get above a certain number that you can have that kind of discussion anymore.
Thank you very much. A wonderful lecture.